Dagne. I'm the Director of IP Osgoode, and I'm the Associate Dean of Research here at Osgoode right now, and I teach IP classes, copyright, trademark, and so on, and I'm not doing these admin roles. I'm also the Director of the Professional LLM in IP, for anyone who might be tempted to engage in a master's program later while lawyering in IP. But for now, I really just want to welcome you to the first of our IP Osgoode speakers series of this academic year. And I'm just delighted that this is being sponsored by our Ontario Research Chair, Tesh Dagne, who I will take an opportunity to introduce in a moment. But first of all, I just wanted to tell you, for anyone who hasn't, who's new, are there anyone else in the room? Yeah, okay, welcome. So you know, we're basically the umbrellas of law and technology, IP law and technology program here at Osgoode. So if you are thinking that you would like to be involved in anything copyright, trademarks, patent, entertainment law, technology law, AI related during your time at Osgoode, then please feel free to reach out. We have some opportunities for writing blogs. We'd like to see people participate in our events, and we have a nice community of interested people. So please do be in touch with me if you want to get involved. But without further ado, I want to introduce our speaker, our wonderful speaker, and our commentator for today. I am really sorry, you may have noticed that our wonderful speaker is two-dimensional right now and behind me on a screen. This is due to visa problems. So this is a problem that's being faced by researchers and universities and students in every walk of life right now. It's a source of huge frustration. Help yourself to lunch. It's just getting started. But with the wonders of technology, we are still able to actually enjoy Chijioke's company. So I'm very glad that we're able to proceed. We also have about the same audience online as we have in the room, and so it's nice for people online to be able to hear that presentation too, and hopefully as well to hear us in the room. So let me just introduce Chijioke, who, and I'm sure she will tell you that she wishes she was here. I know she had a bunch of different research events and travel arrangements set up for this month, and so it's a real shame that she can't join us, and I was personally looking forward to welcoming her in Toronto. She is a National Research Foundation C2 rated researcher. She's the principal investigator and leader of the Data Science Law Lab, which is a research group that deploys research in law and produces evidence and policy advice to support data science research across Africa. So she's also the African correspondent at the IP CAT blog. That's CAT with a K. If you don't read that, you're interested in IP, you should. It's an excellent blog on international comparative IP, with lots of pictures of cats just for fun. And she's also the associate editor of the South African Intellectual Property Journal. She's the author of several articles on IP and information justice issues. She's going to tell us more about what that means. And she was a postdoctoral research fellow with the South African Research Chair in Intellectual Property Innovation and Development at the University of Cape Town before becoming a PhD, what's that? No, PhD, then postdoc at the University of Cape Town, then, let me get this right, in the LLM at the University of Strathclyde, Glasgow. Let's hear it for Strathclyde, Glasgow. And an LLB from Nnamdi Azikiwe University in Nigeria. And she was called as an advocate and a solicitor of the Supreme Court of Nigeria in 2006. Okay, I think that's more than enough, but it goes on and on, trust me. And that's why I'm just delighted that she is here with us today virtually to tell us about her research project on copyright, openness, and inequities, licensing African datasets. Once she finishes, we're going to hear from Tesh. I will introduce him before his comments at that time. So for now, thank you again. Feel free to continue to help yourself with food. Do it quietly if you don't want to attract the attention of the owl. But you're very welcome to stand up and help yourself. Thank you very much, and Chijioke, thank you again, and over to you.
Okay, thanks so much, Caris, for the wonderful introduction. Hi, everyone. I am going to share my slides and start talking. Okay, Caris has already introduced me nicely, so I'm just going to delve into it. I wanted to share my work so far on copyright and openness and inequities as they relate to licensing African datasets. So usually when I talk, I like to situate my my experience into the conversation that I'm having, just so you can maybe have a lot more information about my biases and also what shapes how I think about these issues. So this is where I'm from. I'm from Southeast Nigeria. I'm from Umunze. This is the dance of my people. It's called Mbokiti dance. So much acrobatics, fantastic dance. You should totally watch it. Watch them on YouTube or wherever online. And as Caris have said, I went to Nnamdi Azikiwe University. I practiced law for over 7 years at a law firm now called CLP Legal in Lagos, Nigeria. And then I went to Strathclyde for my master's in internet law and policy. And then I started a legal consultancy called Penguide Advisory. And then I went to the University of Cape Town for my doctoral degree, and then I was a postdoc at the South African Research Chair in Intellectual Property, Innovation and Development. And then I'm now here at the University of Pretoria, and then I started Data Science Law Lab, and we do research around data science issues and also artificial intelligence and technology as it relates to specific African countries, but also the wider African continent. So in terms of what I wanted to share today, it's obviously we'll start with defining some of the concepts that my topic borders on, but then just briefly touch on copyright and other legal rights in African data sets, and then really maybe talk about openness, not maybe actually talk about openness, and then inequities and as they relate to licensing African data set, and some of the guiding principles that have come up in the conversations that I've had with people who are working in this space. So in terms of a definition, data sets are really a collection or an arrangement or a compilation of various forms of data that are presented in a specific manner for an identifiable purpose. So it's not that we are dealing with raw data. It's not that we are dealing with data that we don't know what to do with, or that we are dealing with information in its raw form. But when it comes to data sets, there's some interpretative exercise going on where you are collecting and collating for a particular purpose. And when it comes to African data sets, they are really data sets that are collected and arranged and compiled to solve problems in African context, address African problems. And so they have inseparably embedded in the data, you have African people, African issues, African context. And it is key to proceed from that perspective, because the kind of work and the kind of creative effort and collaboration that goes into creating or producing African data sets has a lot of, let me say, blood and sweat embedded in the work that is done to get it to the point where it's actually doing what it's supposed to do, which is address African context, address or speak to African people and African issues. So when it comes to creating African data sets, there's two broad ways of looking at it. You are either creating from existing material. So this is a pot of egusi soup, one of the soups that we have in Igbo land, but it's also like a Nigerian delicacy. But when you are thinking about it from the perspective of creating African data sets, you have like different ingredients, you have like different people bringing different things to it. So it's either you are having existing materials where you are collecting from maybe a book written in Igbo, a video made in Yoruba, or any kind of language when you're dealing with language data sets anyway, but you are basically collecting data from existing sources, and then you are labeling, you're contextualizing it, you are evaluating it to make sure that it serves the specific purpose that you want it to serve. And obviously remember our definition of how we look at African data sets. But it's also possible to create from scratch, where you have different people working together, different people bringing their knowledge and expertise, and even donating voice and text in their respective languages. If it's a language, if it's a natural language processing project, and so on and so forth. But you could build from scratch, or you could be building from existing materials, and sometimes the two approaches fuse together, and you have data set that is created both from existing materials, but also some aspects of the data that make up the data set are from scratch. So this is a project, one of the projects done by the Masakane Research Foundation. So the Masakane Research Foundation is a foundation is a community of more than 2,000 natural language processing researchers that are working in Africa and are from Africa. So this is one of the projects where they did like text and speech for East African languages. You find that with this project, they are mostly collecting both text and speech data, but for text data, they are focused on getting freely available and open source data sets from existing materials, and they are focused on developing data sets for 4 languages that are spoken in East Africa: the Luganda, Luo language, and 2 other languages as well. And for the speech data, they use the speech voice data from the Mozilla Common Voice platform. There were also people who are adding their own voice donation in terms of data, text and information, and just voice data on their languages, which make up these data sets that they've created. There's also another project called Masakane MT Decolonize Science, where they go to open access journal articles that are published in the science field in various journals, and they collect sentences and text from there to build these data sets. So again, also from that project, you will see articles from news websites that are written in indigenous African languages. You have data from Twitter API, Twitter at the time. You have newspapers, language novels and plays. You have news websites in English and French that people actually translate to their own language just to contribute data to the data sets that are being built or created. You have radio and TV broadcasts. You have, like I've mentioned, preprint papers that are published on journals, and language transcripts that are available on university repository. So when you look at those data sets, and you look at the sources, the data sources that make up the data set, you can, from a legal perspective, start to think about how they could be governed or be regulated by different or a combination of various legal frameworks. So it's possible to think about some of them from the perspective of like indigenous knowledge regimes, or think about some of them from an open access regime, from privacy and data protection law, access and benefit sharing regimes, and then intellectual property, especially copyright, but also trade secrets, contractual regimes, and. So when you look at the data itself, the data sources. It's possible, and that the articles from news websites would be protected by copyright, which would prohibit unauthorized reproduction and adaptation and distribution of those materials. When you think about data from Twitter API, it could be subject of data protection laws. In South Africa, you would be talking about Protection of Personal Information Act. For newspapers, copyright could apply. Language novels, language Bibles, and then for Wikipedia pages, obviously you are thinking about open access regimes. And here you have, like the legal framework that could govern all these data sources. So to now talk about how we arrived to the point of the conversation that we're having today, you would see that you are thinking about all these legal frameworks. You're also thinking about their effect. You're also thinking about the nature of protection that those legal frameworks offer. But down in relation to the data set as an output or as a unit of production. So when you think about the creative efforts and creative input that would have gone into the making of these data sets, they could be subject of copyright protection, and which means that there's exclusive rights, as we know that copyright grants exclusive rights to authors of protected subject matter that allows them to exploit the rights in those work, but allow them to sort of like run a permission-based system where they are permit people that they want to, depending on for how long and for what purpose, in order for them to also exercise the rights that they have exclusively. And the nature of that right is that it's property based. There's data protection law that has to deal with the rights of data subjects, and that places restriction on data controllers in the way and in the manner that they deal with personal information of other people. And the nature of protection in this case is more obligation-based, more liability-based, where you are supposed to comply with specific legal obligations. And then there's contract law, which, because of the principle of freedom of contract, gives some sort of property rights over the data set, even if or over and above whether they are protected by copyright law or not. And then there's trade secrets, there's anti-circumvention provisions that allows one to take practical and technical steps to ensure protection and control and ownership over the data sets that have been created. And that's also sort of like property based, because it's what you do to secure your property rights. So I see this thing like a salon door that swings both ways, where you are either, if you wanted to share African data sets, so you've produced African data sets and you want to share them in whatever shape or form or through whatever means, it could be that the person who needs access to those data sets would approach the right holder when you're thinking about like from a property-based perspective. So the rights are exclusive, it's private, it's permission-based. Or you could be looking at, especially when you think about copyright law, you could be looking at limitations and exception, which is non-exclusive, which is like public, anyone can enjoy it, and it's non-permission based. And so the minute you figure out or you clock that limitations and exceptions apply, you would not need to ask for permission. You just need to proceed to do those activities that are covered by the limitations and exceptions. So when you look at, again, going back to various projects from the Masakani Research Foundation, you will see like the Niger NLP project. What the output from that project was sentiment corpus, sentiment lexicon, hate speech lexicon, and all that. And so because It could probably have some personal information of other people. There's like considerations around complying with data protection laws. When you think about a multilingual parallel corpus, basically like a translation, but in the form of data sets, copyright protection could apply here. And then there's open access regime, and there's contractual regimes, which is more or less tied to open access regime, because you could use a contract or an agreement or a bare license to deal with open access, to provide open access to the data sets that have been created. This is also one source of African data set, because the Lacuna Fund provides funding and support to people who are interested in creating data sets or in producing data sets that speak to issues from low and middle income countries. So you have all these data sets that have been created from doing various things or engaging in various activities. What is common across these activities that led to the production of the data set is that there's either creative efforts going on, or even like there's at least some intentionality in and resources expended in collating and creating and donating and doing whatever to gather data from various sources to ensure that the data set is created, is labeled, is annotated, it's contextualized, it's evaluated to ensure that it is correct and it matches various or specific African contexts. So this one had to do with the agricultural data sets. This one had to do with language data sets, and then there's also the one that had to do with health data sets. So thinking about the creative process of these data sets, or the process of producing these data sets, one of the key ways of sharing these African data sets is through engaging in openness. And so thinking about openness as a concept, we look at openness as something that refers to transparency, reusability, and extensibility. So when you talk about transparency, you say that what is open can be scrutinized, it can be examined, somebody can evaluate it. So during my as part of my doctoral research, one of the main or key focus of my doctoral research was on open business models. So looking at openness in the sphere of business models, you are basically opening up aspects of your business model, whether it's your customers, whether it's your productive process, whether it's the way that you engage with customers, the way that you engage with suppliers, whatever aspect of your business model, but it is transparent. You open it up so that people can see what is going on. Not necessarily for you to be accountable, as it were, even though that's a byproduct of transparency, but for people to see what you're doing and to contribute to it so that you can learn from them and they can learn from you as well. There's also the aspect of openness that speaks to reusability, meaning that what is open can be used by others in different ways, even outside the use that is envisaged or indicated by the person that is opening up whatever. When it comes to extensibility, you're saying that what is open can be built on, it can be extended, it can be expanded. And so when it comes to African data sets, you want to be open in the way that you're creating it. You want to a lot of people, as many people as possible, like using the egusi soup example, for example, you want a lot of ingredients from different sources to make it, a sweet spot, a delicious spot for people to access. But apart from that, you are also thinking about collaborating with other people, especially like when you're creating African data sets from scratch. Now, one of the things that connects the various aspects of openness, whether you're talking about transparency or reusability or extensibility, is that there's some value seen in what is being made open, But there's also value seen in what others can contribute to what is being made open to make it even more effective, even more, positive things. But what openness means in practice varies widely and depends on the context. So in some scenarios, you could have reusability trumping or being above other aspects of openness. But what you will find common in whatever that is open is that there's some elements of transparency, of reusability, of extensibility, and so on and so forth. So practicing openness when it comes to creating or sharing, especially sharing African data sets. There are three main ways. This is research done by Prof Sean Flynn from the American University of in Washington, looking at copyright laws and looking at the research exception and considering or weighing how open or not the research exception is, and arriving at open research exceptions permit all research uses, including sharing of all works by all users, and then started to look at look at openness as something that is on a spectrum where some statutory exceptions are very open or open, and some have different levels of restriction. So exceptions can be one way in which we practice openness, where we exempt certain activities or where we exempt certain people from experiencing copyright protection in the same way as other people, or for different activities as would outside what would be considered copyright protected activities. But you could also practice openness through waivers, where you are issuing a declaration where you are voluntarily relinquishing rights that are ordinarily available to you, or that ordinarily should be enjoyed by you, but you decide that you want to relinquish those rights, you want to waive them, and place the work or the data set as much as possible in the public domain so that people can do whatever they want to do with it. So when you look at waivers, you could see those elements of transparency, of reusability, of extensibility. But the main thing that we started to get into is open data licenses, or generally speaking, open licenses that could be used to share data sets, including African data sets. And then you have the Creative Commons bouquet of licenses. You have licenses from Open Data Commons. You have the Community Data License Agreement. And there are other kinds of open data licenses that are available out there. But these are the standard ones that are quite popular amongst people who share African data sets. So when we looked at three key platforms or repositories where people make their data sets available, Hugging Face, Zenodo, and GitHub, you will find that Creative Commons licenses and Open Data Commons licenses and in recent past Community Data License Agreements, those are the popular standard open data licenses that are used in sharing data sets. What you will find in these open licenses is that it makes provision or tries to address issues around attribution, issues around commercial uses versus non-commercial uses, whether people are allowed to modify the work, adapt or create derivatives out of the work, and whether people are controlled in the way that they share modifications to the data set, whether they are mandated or obligated to share with the same license, or whether they are free to use whatever kind of license that they would use. These standard open licenses also come with some sort of guidance documents, whether it's an explainer, whether it's an infographic, whether it's an actual community norms that explain how the license works, that guides you in terms of the key terms of the license agreement. So you have that, and it's all looking nice and fantastic. There's been a lot of work over the years by various scholars looking specifically at Creative Commons licenses and weighing the pros and cons of Creative Commons licenses for different uses, especially for like the licensees, people who would be using, who would be relying on those licenses to use protected or otherwise, or to use the licensed material. But we started to think about inequity as a legal principle, and I'm sure that a lot of us, if not all of us, are familiar with this representation of the difference between equality and equity. So where equality tries to place everyone at the same on the same level, on the same footing, equity tries to meet each person where they are in order to achieve an outcome that is fair, that is equitable, that brings justice to the situation. So when we think about the inequities that come within sharing or licensing African dataset, one of the things that started to come out in the conversations that we've had and that I have had specifically with various people who are creating African datasets. I've been to the deep learning in Daba, which is like the largest gathering of machine learning and AI researchers that are working on Africa, that are working in Africa, most of them from the continent as well. Some of the things that come out in the conversations when it comes to how the effect or the impact of using open data licenses to share African data set is that you find that when it comes to exceptions, especially in copyright law or particularly in copyright law, you will find that they speak mostly to activities, but not to people and their context. And one good exemplar is the one that is in the blind essay against Minister of Trade, Industry and Competition and others, which was a decision of the South African Constitutional Court in 2022. The long and short of that case was that Blind SA, which is the Association of People with Visual Disability, what they were saying was that the way that copyright law operates requires them to ask for permission for every and anything that relates to copyright protected work. So if they wanted to even make copyright work in an accessible format that someone with such visual disability can be able to access the work, it's difficult, if not impossible, because they would need to obtain permission every single time. And the point that the Constitutional Court made in that case is that in relation to the constitutional rights of freedom from discrimination, that it is sometimes imperative and necessary to treat different people differently so that you can achieve the same but equitable outcome. So if you were to be on the tack of equality, where you're treating people with visual disability in the same way you're treating people who don't have such disability, you would have equality, but you would not have equity. And so the court looked to that situation and mentioned the fact that the Marrakesh Treaty was actually acknowledged that it was actually the first treaty that specifically spoke to specific people with visual disability and their specific context. The second inequity that has been shown to apply is that when you look at the applicable exceptions, and you look at open data licenses, you will find that they are not explained or described. And so the question of what is outside the scope of that license, in terms of that there's no need for the license in the first place for that is not really, it's vague and it's not really explained. And so what it does is that it forces users to focus on activities that are explicitly permitted by the license. And so if there are activities that would have been possible because of exceptions, there's not much attention or mind paid to that. The other one is that when you look at exchanges, in terms of obtaining an open data license or using an open data license to share, exchanges are usually perceived as closed. So when you look at the discourse on share alike obligations in open licenses, there's always usually the focus on talking about how they are restrictive. But when you want to think about putting or placing obligations for some sort of exchange, there's that look as to whether it's only limited to cash, and makes it sort of like dilutes from the good aspects of open licenses or of openness. But you will find that exchanges can be, share alike, where you are just saying you want to continue this culture of continuing to spread these African data sets as and for people to have access and also share and allow access to modifications that they've made to the data sets that they've had access to because of a given open license. The other key inequity is that users of, that is the licensees, in the case of openly licensed materials, are treated the same when the reality is actually not the case. And one good example, or one key example, is that you find that when you make African data sets, when you share them using an open data license, where people don't have obligations to either provide some benefit or respond to some issue or interest that the licensors may have, you find that people with more access to better resources, better infrastructure, are able to make immediate or quick and effective use of the data set into creating AI products, into building AI models. But the people who don't have as much access or any access to such infrastructure are not able to do so. So there's that imbalance, which is what inequity is about. This is a paper that I wrote with my colleague at the University of Pretoria, Vukosi Marivate, who is in computer science. And so we were basically with this paper thinking about issues around, on one hand, navigating the challenges of copyright and innovation and access through open licenses, but also looking at open licenses in respect of these issues that I have just highlighted. These are some of the people that are working on African data sets. So there are content creators, there are language technologists, language innovators, and so on and so forth. These are people who work in these spaces and who make major contributions and key contributions to creating African data sets. And when you look at their contribution and look at the key things that are highlighted in open licenses, there's some sort of disconnect, as I have highlighted in a couple previous slides ago. And so we started to collate questions that we have gotten or we've received from people who are working on these spaces. Something like, how do I ensure that others like me, others who are in the same position as I am, with limited access to resources like compute, with limited access to development frameworks, with limited access to other infrastructure that might be needed to make meaningful use of the data sets that they are creating. How do I make sure that they are able to use the outputs, to use the data sets in the way that I am able to do so? Do I or others like me own or have effective and working access to compute and other infrastructure to do more with my outputs? How should I address rights and ownership for AI modules that are developed using my data sets? So those are some of the questions that highlight the inequities that I have already mentioned. And so you find that users are actually not on the same plane, but it's like a seesaw situation where there are some users, all users are equal, but some are more equal than others. So it's actually not, everyone is actually not the same. So you would need support for the people that are under for them to actually come up to the same level or to the same point where other people are. And that's how you achieve equitable outcomes. And so these are some of the pillars of equitable openness that have emerged from thinking about solutions to this issue, that licenses need to make provision for or acknowledge, or provisions that acknowledge that users of African datasets have different contexts, different capabilities, that benefits don't necessarily have to be financial, and that community data work needs agency, and that licensing is just one way of sharing, and we should think about how we operationalize exceptions. We should think about situations that are more amenable or more aligned to waivers or relinquishment of rights. And so it's not just a licensing thing. There's various ways of sharing innovation in this space in terms of creating African data sets. So this is it. Thank you so much. And I'm looking forward to comments, questions, and more engagement.
Thank you so much, Chijioke. That was fantastic. So I'm just going to quickly introduce our commentator. Unfortunately, we only have one commentator, and we're supposed to have two. But Celeste Herco, who you may know as the copyright law professor this year, is unfortunately not well enough to speak to us today. So sorry about that, but Tesh has promised to speak for twice as long and say twice as much in his comments now. So just to introduce you to Tesh, you may also be known already to some of you from such favourites as Property Law 1L. Where he's teaching adjunct this year. If you haven't had him yet, he's teaching this year in winter. He's also the Ontario Research Chair in Governing Artificial Intelligence. And that chair is bringing us today's lunch, so I hope you're enjoying that. He's previously taught at Thomson Rivers University Faculty of Law and Schulich School of Law at Dalhousie, where he earned his doctoral degree and was a Schulich Research Fellow. So thank you very much, Tesh. I'm going to give you the podium so you can speak to the owl and the people, and then we're going to open things up to questions. So if you have questions, take a note of them now, and I'll try to moderate that conversation after. Thank you.
All right, thank you very much. I'm going to take half an hour to make my speech. No, thank you, Chijioke, for this very informative and very important presentation. And also thank you, Doris, for organizing it and for putting together the event. Chijioke demonstrated to us the complexities of promoting openness in African intelligence development within African context and in the global south. Openness, of course, involves sharing data and models to enable access, transparency, use, and reuse. It can foster collaboration, innovation, and inclusion in AI. However, it also raises those issues that were just outlined related to privacy, copyright, and more importantly, the agency of data contributors and African community of researchers. In her presentation, and I have read the accompanying article as well that Chijioke and her co-author published. They used examples from grassroots AI communities to highlight how these groups rely on openness to advance African natural language processing technologies. But the first tension due to differing interests in among stakeholders in the context of the data or the data set. Those concerns relate to commercialization and, more importantly, community ownership of data. So the core of the argument seems to be that while openness has contributed to AI development in this context, it must be practiced in a manner that respects the rights and autonomy of local communities and peoples in the region. Obviously, existing copyright and privacy frameworks do not adequately address issues of agency ownership when data is openly shared. That potentially leads to exploitation and exclusion. All in all, Chijoke's presentation and her article on which her presentation was based raised three major questions. A, how can openness in AI be practiced in a way that respects and preserves the agency and autonomy of all these community of researchers, individuals, contributors, indigenous knowledge contributors, etc. in the global south? The presentation challenges us to think about whether current models of openness of varied types that we saw adequately consider the rights and interests of data contributors, suggesting a need for more context-specific approach. Other distinct corporate and private frameworks, such as to address the issue of community ownership and control over data and AI development. Of course, there are limitations that were highlighted under the current legal regimes, largely dealing with the proprietary and private rights of data sources, especially when openness is embraced without nuances. So, if that's the case, what legal frameworks or policies can balance the need for open collaboration in AI with the commercial interests of, on one hand, and the cultural rights of different stakeholders that we saw are collaborating? Here, the presentation underscores the tension between fostering innovations of openness and ensuring fair representation, agency, and recognition of data contributors. I will conclude my comments by forwarding two questions that Chijioke and her author Chijioke might address now, but might also think about. What specific policy changes or adjustments to open sharing regimes would help reconcile the goals of openness with protecting the proprietary and privacy rights in the global south? In her article, Chijioke mentioned the possibility of using contracts and private ordering regimes as having an immediate benefit, followed by a comprehensive regime of change such as that in the EU AI Act. However, given the power asymmetry between global AI businesses and African researchers and developers, is it feasible that we have solution in this private ordering and contract regimes of licensing? The second question is, are there successful models outside of open licenses? Could there be? There is much talk about alternative models of data ownership through data cooperatives or the community managed data trusts. Are there any examples in other regions of the global south or in parts of the north that may have balance openness with community agencies, which could be adapted in the African context? With that, I open my comments and I will open the floor for discussions.
Thank you very much. Okay, I'm going to pop myself here, and if anyone online has any questions you'd like to, you can raise your hand, and then you can open your camera and unmute yourself and ask. So I see already Damla in line, that's fantastic. And feel free to type in the chat as well, we'll monitor that. And also, anyone in the room, just raise your hand and I'll call you out or keep a list if there are questions. I have a lot, but I'm going to hold them for a moment and start. I think Damla, you're up first. Let's hear from you.
Yeah, thank you, Prof. Craig. Dr. Okorie, it's good to see you again. I mean, we saw in February, March. Interesting conversation, interesting topic. I really enjoyed it. I was wondering why you were presenting, because you mentioned the issue of agency, African agency over these data sets. I don't know if you've considered ideas from the DMCA, for example, in the EU, how such ideas could help address the issue of agency. For example, data portability and interoperability. because I know one of the inventions of the GDPR is portability. How meaning data owners, individuals have autonomy to move their data set from one platform to another. So I would like to know your thought on this, especially regarding how it could ensure that there is fairness in the use of African data sets. And thinking more broadly, because you, Professor Tesh mentioned your article with Dr. I can't recall his name now. Your co-author, where you mentioned the issue of private ordering. Like Dr. Tesh said, one of the issues even copyright scholars are grappling with is power asymmetry, right? How right holders, big firms, have the say over who gets what in terms of private ordering, even beyond the limits permitted by copyright. Have you given a thought on what competition principles could do in this regard to rein in these platform powers? Thank you.
Chijioke, you have a couple of questions already lined up, then I actually didn't give you the opportunity to answer Tesh directly either. You need to tackle in whatever order you want. But yeah, back over to you.
Okay. So I think the questions that Tesh raised, thank you, Tesh, and also thank you, Damola. I think they are interconnected. So I will just answer them in one fell swoop, I hope. So the thing with this particular project is that at the time that I wrote the paper with Vukosi, my colleague, it was more that we were thinking about highlighting the issues. So at that point, it was something that we were looking at from the perspective of what are the problems in this space. And one of the main things at the time was this issue of urgency, of recognizing the various people that have made input into making the data set what it is or what it ends up being, and who add value to the data set, who make it valuable for the AI value chain. And at that time, I started thinking about the fact that the existing open licenses like Creative Commons, Open Data Commons, and so on and so forth are quite popular with people in that space. And one of the major reasons why they are popular is because they are easy to understand. People want to know already what they are giving up or what they are not giving up. But one of the things that happen in that space is that there's a lot more predilection to using CC0, which is a waiver more than a license. And in that kind of space, because you're waiving, you don't have to think about any other issue other than to just give this thing away and be done with it. But the issues that it raises are some of the inequities that I have mentioned. So when I thought about what specific changes would help to reconcile the benefits of openness with these issues around agency, with these issues around other inequities, one of the things that came up is that we need to rethink the way that these licenses are structured. We did actually end up in a project funded by Mozilla. We did actually end up coming up with a new license agreement. And in that license, we try to address this issue of treating users the same when they are actually not, in terms of context, in terms of position. So that's, I think, one way of addressing the issue. obviously, there are alternative models in other legal frameworks, like Tesh mentioned about data cooperatives, which is a thing. There's also, using competition law to address those issues. I'm sure you remember, Demola, that we were working on a project when you visited us at the University of Pretoria, where we were looking at other regulators that are in the space of dealing with platforms that handle some of these data sets and looking at where they sit from a competition law perspective. But one of the things and one of the limitations of competition law, which funny enough was part of the things that on one hand tried to drive me crazy during my doctoral research, but also on the other hand made my doctoral research groundbreaking, even if I say so myself, was that, like, when you think about market power, how do you define a relevant market, and how do you define what market power is in that space? And that is something that has led to scholars like myself proposing that competition law from an Africa perspective must try to create that distinction where in some instances it's easy to and straightforward to determine a given market and determine who the dominant player is using metrics like turnover and so on and so forth. But to think about market power, even if it's in relation to a contractual situation, even if it's in relation to a private ordering situation. So are there alternative models that can address some of the inequities that I have raised? Absolutely. What I am just saying with this project is that it is also possible to re-evaluate the open licenses that are out there and make them more useful, because private ordering will still continue to happen, will still continue to be a thing in this space.
Okay, any other questions of the river online, or shall I take my stat? I'm going to use Celeste's stat. Oh, you go back. Perfect. Okay. Yes. Okay.
Can you hear me?
Yeah, you might want to just project a little bit.
Okay.
It's natural, but yes.
Okay. Hi, my name is Serena. I'm a first-year student at Osgoode, so all I know about IP law is what you said today. So this is a dumb question. I do apologize. But basically, I have a really, I think, a genuine interest in the intersection between social justice, access to justice, and fields like intellectual property law. My understanding is that at the base level, we're looking at equal access, procedural equality, and equity in terms of like the beneficial impact of intellectual property created by others. I guess my question is, and I do apologize again if you've already answered this, but what's can the West take to support the equitable openness of the global majority for access to IP law?
Okay, so the way that I look at it is this. I think that the starting point is to look at the African continent and the global South generally, to look to them for the solution to the issues that they do have. And I think that from like a Western or global North perspective, Africa must lead in terms of saying these are the issues and this is how they should be addressed, and they should do more of listening than coming to solve whatever problems that they see on ground, because there's actually people who are living these problems, these issues. This is their life, and they have already, they are thinking about solutions to those issues. The thing with IP law, especially copyright, in this space, is that the way that it is set up can sometimes be in would I say opposition to the way that the creative and collaborative process happens on the African continent. So whereas in maybe from a global North perspective, it is possible to have firms who are creating protected or protectable subject matter in terms of like creating African data sets, creating data sets, creating AI modules. Because it's possible to like identify people who are working in that space. It's not the same with what happens on the African continent. One of the things when it comes to even something like languages, for example, if you wanted to create data sets for any task and it's in English, it's easy to get materials, to get data sets on the internet. But if you wanted to create the same thing for an African language, you would have to build from scratch. And to do that, you're going to have to leverage on people in local communities, researchers who speak the language, but are not necessarily working in that tech space. So I'll give you maybe a funny example. I wrote a book chapter, I think last year, and the editors of the volume said to me that they were looking to make the abstract more accessible, and so they wanted to have people write in an additional language. So they said, so Chijioke, you can actually write your abstract in English and in another language. So I said, okay, let me write in French, but I don't speak French. So, and they were like, oh, okay, French is good. How are you going to write? I said, no, I actually don't speak French. I was planning to use Google Translate. And so they were like, oh, wow, you can actually write in your language. And I said, oh, great, because I don't think in English. I think in Igbo, which is my language. And so I was like, why was it like the first thing that came to my mind was to write in French? But I think what happened was because I was thinking, like accessibility in Africa, if I could, Anglophone Africa and then Francophone Africa, so French would be a good thing. But it would have been nice if I was thinking about that and I could speak French, So I ended up fantastic. I ended up writing the abstract in Igbo. And it was a struggle, not because I struggle in Igbo, I don't, but because I had written the abstract in English and I was now translating, back to, so it was a struggle first to move my thoughts into English and do the abstract. And now I had to go back again and write in Igbo. And I can assure you that any Igbo speaker who reads the abstract will see that I said more like from the heart in terms of what I was saying with the abstract than I said in English. So all this is to say that it's important, if anyone wanted to address the issues that the global majority has with this in this space, to look to the continent itself and to look to the global majority itself in trying to address those issues. I hope that I have answered your question.
Thank you.
Great, thank you so much. Any other questions in the room? So I don't see anything else. I'm going to take a stab just at mine, which was, so for people, I think, I haven't probably taught most of you copyright law, but I think Chijioke will know and Tesh will as well. I'm kind of a copyright minimalist when it comes to how much we should protect. I'm a copyright skeptic, right? I'm not really a big fan of using copyright to limit access to information and expression. And so that's always my starting point. And what that means is that when I look at, I don't know very much about copyright law in Africa generally. I know a little bit about South Africa, and I think that recently in South Africa and Canada, I've seen it as a sort of model, right? The push towards fair use, so kind of opening up some exceptions for copyright to allow more free, fair usage of copyright protected works is kind of an equity-oriented goal, right? Because it's about access to educational materials and so on. And so I find that really compelling. The blind essay case in South Africa that actually says, this is a constitutional issue, whether you can access works, it's a freedom of expression issue, it's a quality issue, it's protection against discrimination. We haven't done that in Canada, really recognise the constitutional relevance of copyright limitations. So I think that's terrific. And then when we look at the sort of question about text and data mining, and can you use
works to train artificial intelligence, what we see is that in the Sean Flynn study there, that many of the African regimes just don't leave space in the copyright system for people to be using materials in that fair, lawful way to train artificial intelligence systems or to extract or analyze data. So coming in, I always think, well, openness is the solution. I'm very skeptical always about the idea that sort of property structures like copyright are going to bring or enhance equity. Mostly just my shortcut is to say because they're fundamentally about exclusion. And when people are going to be excluded from things, like you can always guess who's going to be excluded and who's going to benefit, and it's not going to produce more equality. I think it tends to produce less. So that's like my entrance point to the question which I'm going to ask, which is whether, because you'll have seen, like what I love about Chijioke's work is the way it layers social justice onto the data and copyright debate. But I always worry about the unintended consequences of these kinds of moves, right? So I can imagine it backfiring in like just a couple of different ways. One of them, I think, is that when you start placing limits...
Close that door.
Using Chijioke, don't believe it. When you start placing limits to openness, are you re-entrenching or reinforcing a property-based approach to the works, to the data, to the cultural artifacts, and so on, that ultimately is going to backfire, in my view, because it ends up excluding more people and creating more sort of profit-driven activities around it. So the re-entrenchment of property structures like copyright that might ultimately harm equity. And then the other one, I think, is just that when it comes to AI training, like the languages thing is a perfect example. I find it interesting to think about inclusivity and exclusivity. And right now the push seems to be on, we need to exclude things from data sets because it's not fair to use them. And I worry that when things are excluded from data sets, the data sets become less representative, the data becomes much narrower, the worldview becomes much more hegemonic in terms of what they can produce. And that actually people should be arguing like we want to be in the data set because we want to be representative, we want the outputs to be fair, we want to be involved. So Mikhail Okorie writes about this, about the narrowing of worldviews. If everything we think is what ChatGPT tells us, and it's all based upon American data. And so in some ways, I think the push should be about more inclusion and more openness and actually demanding to be included in data sets rather than placing limitations that might just be an extra obstacle, so you end up being excluded. So that's my question.
Okay, so the thing is, from where I sit, I am trying to present a way of dealing with licensing, for example, if that is the approach that we want to take. So, and that is why I said when you want to practice openness, there are different ways of practicing openness. And it could be that you are using copyright exceptions, for example. It could be that you are waiving rights that you might ordinarily be able to assert. It could also be that you decide that a license would be a way to address it. So, and then obviously now narrowing down on assuming that this was a situation where you felt that the best way to approach this thing was to use an open license to practice openness. Then how do you practice openness? If excluding and exclusivity is the problem, how do you practice inclusivity in a way that is equitable? So, for example, I remember that even now as we speak, there's been a running issue where my colleagues who are in computer science are doing this project where they wanted to have access to data, which is really radio broadcast and TV broadcast, which embodies like different ordinarily maybe copyright protectable subject matter that are being held by the public service broadcaster. the one public service broadcaster in South Africa. And it's been a thing where they have been saying, no, we have copyright in these materials, and we would want to either license them for money, or if we were giving them away for free, then whatever you create from using those materials, we would own copyright in those materials. And because of the fact that these researchers wanted to share the outputs, openly, wanted to make them openly available, such kind of license agreement wouldn't make sense for the end goal of the project. So in that kind of space, I have argued that this is a space where number one, this should be public data because of the nature of the organization involved, because it has constitutional duty to generate those data in the first place in the performance of its statutory duties anyway. But even if that were not the case, because this is for research purposes, the fair dealing exception should apply in this space, and they should be able to use that. So I have that kind of issue and that kind of thinking and that kind of experience at the back of my mind, even as I speak about licensing as one approach of practicing openness, right? So we need to deal with exceptions, especially because it can save us at the end of the day in terms of how we approach whether it's propertizing things in this space. But even outside scenarios where exceptions might not really apply, because when you think about the fact that they are not permission based, the fact that once they apply, there's no need to request for permission and all of those things, you then need to still think about how do I recognize the contributions of the stakeholders, the communities in this space. So maybe copyright might not be the tool with which you use to address them or address their interests. Maybe it could be labor laws, but which still would bring us to contract issues, because how do you negotiate what is an appropriate, whether it's remuneration, whether it's some sort of compensation, whether it's some sort of benefit sharing, whatever it is that you decide to do, there would be some sort of agreement or document that encapsulates the obligations and interest in that space. And which is why I tend to say, copyright and other legal rights, which could operate in this space, based on whatever legal framework that might make sense for the specific issues that we're dealing with.
Wonderful, thank you. So just much more nuanced and much more context specific than I have been in my explanation. So I really appreciate you explaining that, and I very much appreciate you taking the time to join us today online. I don't see any further questions, so I really just want to, you can understand why it would be lovely to have her here so that we can continue the conversation. But I'm sure you'll welcome people reaching out if they want to. And we're going to be writing this up on the IP Osgoode website, the blog, the epilogue. So please stay tuned for that and a few other future posts that are going to be coming out soon. One of them written by John Dagne in the room about Amanda Turnbull, and one of them written about Damola, who you heard from today, about Tesh's work. So do read that, do visit the website, do stay in touch, and follow us on the socials. And we will, I'm sure, pick up this conversation. But thank you so much to Chijioke for joining us today. It's been such an illuminating presentation and discussion. And thank you to everybody who joined us in the Zoom room, and everybody who joined us in the real room, in real life. And we're
Thank you so much.
Sorry, I interrupted you there.
No, thank you so much, everyone. I really appreciate that technology allowed us to have this conversation today. And I'm looking forward to engaging more and thinking more about these issues, because I think they will benefit from, continuous thinking, continuous reconsideration, nuancing and explaining and distilling what the issues are, so that when we do find solutions that make sense, they actually do make sense and respond to the problems that are on ground.
Well, thank you again very much. The room immediately, so feel free if you want to stick around and chat for a little bit. And similarly in the room, there's still some food that you can help yourself to. But otherwise, great to see you and look forward to seeing you in the next one.
Bye, everyone.
Thank you.
Okay.